A dangerously compromised Supreme Court decides if Trump is eligible to be president again. All that and more now on Graph's Grievances. In less than 24 hours, the Supreme Court of the United States will hear oral arguments in a case that could radically upend American history and the 2024 presidential campaign. The High Court is being asked to decide whether Donald Trump is eligible to be president again following his actions on and around the January 6th attack on the U.S. Capitol. In December, a divided Colorado Supreme Court ordered Trump to be excluded from the state's presidential primary ballot because, they concluded, Trump violated Section 3 of the 14th Amendment. The Constitution's insurrection clause bars anyone who swore an oath as an officer of the United States to support the Constitution and then engaged in an insurrection or rebellion from holding office ever again. So, in hearing Trump's appeal of the Colorado ruling, the Supreme Court seems to be facing three major questions. 1. Did Trump engage in an insurrection? 2. Does the 14th Amendment apply to the president? Some lawyers argue the president is not a, quote, officer of the United States. And 3. Does Colorado law allow for the removal of a candidate from the ballot? Remember, the 14th Amendment bars an insurrectionist from, quote, holding any office, not necessarily running for president and appearing on the ballot. And yes, there are seemingly endless other questions, but these are the big ones in my mind. Of course, I am not a lawyer, but sadly, I do not think that matters in helping you understand whatever decision we get from the Supreme Court regarding Trump's eligibility to be president again. And that is because the highest court in the land has unquestionably become a partisan institution that is no longer committed to putting the Constitution and the rule of law above politics. Think about this. As the Supreme Court hears oral arguments tomorrow about whether Trump engaged in an insurrection, one of the justices who will be listening and ruling is married to a woman who played a key role in trying to overturn the results of the 2020 election. Supreme Court Justice Clarence Thomas's wife, Virginia Ginny Thomas, helped organize and attended the Stop the Steal rally on January 6th, where Trump called on his followers to, quote, fight like hell and stop the certification of Joe Biden's election victory. Ginny Thomas also sent text messages to President Trump's White House Chief of Staff, Mark Meadows, urging him to stand firm and stop, quote, Biden and the left from attempting the greatest heist of our history. All of this after Biden already won the election. Ginny also pressured Arizona state lawmakers to illegally set aside Biden's popular vote victory there and keep Trump in office by choosing an alternative slate of fake Trump electors. In addition to all of this being extremely legally dubious, Ginny's actions raise serious questions about her husband's impartiality. According to the new ethics code all 9 Supreme Court justices signed just last year, they pledged to step aside from a case when, quote, impartiality might be reasonably questioned, or when a justice or a spouse has a financial interest in a dispute. Yet irrespective of this clear language, Thomas will be on the bench tomorrow as the Supreme Court decides whether Trump engaged in an insurrection his wife promoted and helped organize. And yes, Thomas is just one of 9 justices, but the fact that he indignantly refuses to recuse himself and uphold the integrity of the court spoils the entire institution. Whether Trump is eligible to be president or not, will not be decided by brilliant oral arguments and masterfully articulated judicial philosophy. No, this critical question of whether a twice impeached former president can hold office again will be decided by politics. In addition to Thomas, 3 other members of the High Court also raised concerns about their impartiality regarding Trump's eligibility. Chief Justice John Roberts, Justice Amy Coney Barrett, and Justice Brett Kavanaugh all assisted George W. Bush in litigation surrounding Bush v. Gore. That landmark Supreme Court case, which permanently ended Florida's recount of its 2000 election results, guaranteeing that Bush, who was narrowly ahead as votes were still being counted, would win Florida and the presidency, no matter what the final vote count would have been. All 5 Republican-appointed justices siding with Bush, while all 4 Democratic-appointed justices siding with Gore and arguing that vote counting should continue. Perhaps the single most corrupt decision in Supreme Court history, aided by 2 future Supreme Court justices and 1 future Chief Justice. And because those 3 justices, along with Justice Thomas, will not recuse themselves from Trump's Colorado case tomorrow, America will soon have a new most corrupt decision in Supreme Court history. Thank you for watching Drafts Grievances. Let me know what you think. Please like, subscribe, share. It really helps me grow this channel. And join me tomorrow for more.